Inauguration of the newly constructed building of Lakhipur Judicial Court. I extend my heartfelt congratulations to all the judicial officers, staff, advocates, and the people of Lakhipur associated with the region's legal services. The inauguration of the judicial building will not only enhance the efficiency of the judiciary in Lakhipur and Cachar district, but will also have a positive impact on fulfilling the aspiration of the people across the Barak Valley. Lakhipur, surrounded by the Barak and Speedy river, witnessed a historic moment in this judicial journey with the inauguration of the Sub-Divisional Judicial Court and Civil Court, including the Court of the Judicial Magistrate First Class on November 19, 2016. Since then, this court has been functioning from rented premises. The construction of their own building began in March 2018 and has now been completed at a cost of approximately rupees 3.78 crore. Today, this new building is being dedicated to the service of the people. Initially, 3 Katha and 7 Lesa of land were allotted for the building, and in October last year, the district administration provided an additional 4 Katha and 15 Lesa of land, with Lakhipur now recognized as a co-district. This new judicial building is expected to play a significant role in shaping the future of the judiciary in the region. Our modern Indian judiciary is in part a legacy of the legal system introduced by the British in the mid-19th century. However, India has a rich tradition of well-structured and evolved system of justice dating back to ancient times. In those days, the foundation of the law was the Dharma, and during the composition of the Dharma Shastras, codes of conduct for citizens were established. Following these codes were essential for maintaining peace and order in the society. In ancient India, social rules and regulations were considered laws. These laws not only govern individual behavior but also held the authority of royal decrees. The king had the power to enforce punishment, but it was his duty to uphold the principle laid down in the Dharma Shastras. In the absence of specific provision, the king could draw upon precedents, but he was not allowed to impose laws based on personal whims. Kautilya's Arthashastra mentioned that the judiciary and legal framework were among the 7 vital components of a state. In South India, during the reign of Chola dynasty, village assemblies played a key role in resolving disputes among citizens. With the arrival of the British, however, the judicial system in India underwent a significant transformation, marking the beginning of a new era in country's legal history. During the colonial period, the entire judicial jurisdiction of the Northeast India fell under the authority of the Calcutta High Court. In 1880, for the first time, a judicial commissioner was appointed to assist the chief commissioner in the administrative function of Brahmaputra Valley district. By 1903, a more comprehensive judicial system had been established across most parts of Assam. However, even at that time, the Calcutta High Court continued to maintain its authority over the judicial administration of the region. After Assam was granted the status of a governor province in 1921, the demand for establishing a high court in the region gained momentum. The process received a significant boost under the Government of India Act 1935, which paved the way for establishment of a federal court to hear appeals from High Court. During the British rule, the matter of setting up a High Court in Assam was raised multiple times in both the Legislative Council and Legislative Assembly, sparking extensive discussion and deliberation on the subject. After India's independence, the demand for a separate high court in Assam gained renewed momentum. On September 9, 1947, the Assam Legislative Assembly passed a resolution supporting the establishment of a high court for Assam. This resolution laid the groundwork for Governor General of India to issue an order March 1, 1948, creating a high court for the state of Assam. The order came into effect on April 5, 1948. Through this order, the judicial authority and jurisdiction that the Calcutta High Court had exercised over the Assam provinces were officially transferred to the new High Court of Assam. Additionally, the state's High Court was also granted jurisdiction over the hill areas of Assam, which were not previously under the purview of the Calcutta High Court. As per the 1948 order, the jurisdiction of the High Court of Assam was extended to cover every corner of the state. Before independence, the judicial administration of Cachar district, the heart of Barak Valley, was under Sylhet Sodar Court with a circuit court operating in Silchar. After independence, the undivided Cachar district came under the jurisdiction of the Jorhat district and Sodar Judge. To address the legal needs of the district and expand its judicial framework, a separate and independent post of district judge for Cachar was created in 1955. Through this long journey of judicial evolution, Assam has now developed a robust district judiciary under the jurisdiction of the Gauhati High Court, reflecting significant progress in ensuring justice and legal services across the state. Since formation of our government, we have inaugurated new district judicial court building in Borpeta and Sibsagar district. Similarly, in November 23, the Sub-Divisional Judicial Magistrate Court building in Bukakhat under Golaghat district was also inaugurated. These new court buildings, in addition to the housing courtrooms and chamber for the judges, are equipped with modern facilities such as libraries, video conferencing room, various office space, a vulnerable witness deposition center, meditation rooms, and CCTV control rooms, among other advanced amenities. Additionally, the construction of the court complex and residential quarter in Dhuburi, Gwalpara, Tinsukia and Gauhati is progressing at a fast pace. The construction work of the court complex in Gwalpara and Dorang district is almost complete. Soon the court complex being built in Difu will also be inaugurated. In addition, district judicial system have been established in the newly formed district of South Salmara, Mankasar, Bajali, Bishwanath, Majuli and West Karbi Anglong. Our government has left no stone unturned in turning Honorable Prime Minister Sri Narendra Modi's vision of ease of justice into reality. In order to bring the judiciary closer to the common people and implement these noble ideals, we have taken several steps to make justice more accessible. To protect children from the sexual abuse and ensure swift resolution of cases related to child marriage, POSCO courts have been established in 17 districts. These courts have been set up in the district of Baksa, Cachar, Kokrajhar, Nalbari, Sunitpur, Nagaon, Karbi Anglong, Borpeta, Dhuburi, Golaghat, Kamrup Metro, Kamrup, Lakhipur, Morigaon, Sibsagar, Tinsukia. Two such courts have also established in Nagaon district. With the state's economic development, the number of the commercial dispute has increased. In this context, a plan has been made to establish a dedicated commercial court in Gauhati. Similarly, a specialized NDPS court is also being planned. Efforts are also underway to establish a director of prosecution in the state. This directorate will function as a controlling authority for all administrative tasks related to prosecution. It will also oversee the work of the Deputy Director of Prosecution, Public Prosecutor, Additional Public Prosecutor, and Assistant Public Prosecutor. The recruitment process for this directorate have already been initiated. To reduce the number of pending cases in courts and decrease the number of prisoners, our government has implemented measures under Section 321 of erstwhile CRPC 1973 to withdraw petty cases. Under this initiative, nearly 81,000 petty cases were withdrawn by March this year. To ensure a safe environment for witness, safe deposition centers have been established and several of these centers are already operationalized. Through the implementation of e-filing system and virtual hearing, which Honorable Chief Justice has just mentioned, the court procedure have been transitioned to a paperless system. E-service center and mobile app Borsa have been launched to provide affordable legal information and emergency assistance to distressed women. Under the strong leadership of Honorable Prime Minister Shri Narendra Modi, India has ushered in a revolutionary transformation in its legal framework by replacing colonial era Indian Penal Codes, Code of Criminal Procedure and Indian Evidence Act with Bharatiya Nyaya Sanhita, Bharatiya Nagarik Suraksha Sanhita and Bharatiya Shiksha Adhiniyam. This new legal framework has facilitated more efficient and technology-driven judicial process, making justice delivery smoother and reducing the burden of excessive cases on the judicial system. With a focus on expediting justice and prioritizing reforms for the rehabilitation of criminals and victims, this new laws aims to build a more just and equitable society. This judicial code brings reform in punishment, investigation, trial procedure, remove unnecessary provision and emphasizes the growing role of digital technology in the court system. These changes highlights the transformation of the criminal justice system, taking our legal framework to new heights. The Bharatiya Shiksha Adhiniyam now places special emphasis on the use of scientific methods for the collection of evidence. As a result, in coming days, the role of forensic expert in the investigation process will significantly increase. To support this, the construction of the National Forensic Science University campus in Gauhati has already begun. This university will provide advanced training opportunities to investigative officers, enhancing the scientific approach to criminal investigation. Additionally, along with the training of police officials on the new criminal law, special attention is being given to appropriate use of information technology in law enforcement and investigation. Under the new laws, cases must be resolved within a specific time frame. As per the new codification, both judicial and administrative procedure have been made time-bound. To ensure that our judicial system keep pace with evolving circumstances, it is imperative to invest in the necessary resources and build a strong infrastructure. The newly inaugurated judicial buildings will play a crucial role in meeting the present day requirement and will significantly contribute to strengthening of the judicial framework, ensuring timely and efficient justice delivery. To ensure the effective implementation of the new criminal laws, which came into the force in July this year, a system has already been put in place for the registration of all public prosecutors, additional public prosecutors, and assistant public prosecutors under central government's integrated training portal called Karma Yogi. This initiative aims to provide them with necessary training and resources to better understand and implement the provision of the new laws, further enhancing the efficiency and effectiveness of criminal justice system. I was little apprehensive when we have to undertake the journey from IPC CRPC to the Nyaya Sanhita in July. But because of the effective intervention of the Gauhati High Court, the training process Gauhati High Court initiated for the judicial officers, for lawyers, the transition is was very, very smooth. I was apprehensive that there will be lot of chaos, there will be lot of difficulties in the initial days. But the smooth transition from the colonial era laws to the Nyaya Sanhitas in fact represent the kind of quality we have in our judicial system. I am very proud that Assam is one of such states where transition is very smooth, and this is one of the huge achievement for our judiciary. I want to offer my deep gratefulness to the Honorable Chief Justice for this initiative and for leading this transformative journey. Without the active assistance and active involvement of Gauhati High Court, it would not have been possible. The district judiciary, the lawyers, everybody coopted to the system, and they made the journey very smooth. So I must record my deep appreciation to entire judicial fraternity for this great and successful transformative journey. As we all know that under this new criminal Sanhitas, the disposal of cases has been made time bound. When I came to attend the function of Cachar district bar, that time also I have emphasized that it is important for us to give justice in a time-bound manner to the society. Particularly, I will once again appeal that when it is a case related to women, related to child, I think our advocate must cooperate with judiciary so that we can render justice to the victim immediately. In that meeting also I have requested to all the advocates that when it relates to a crime against women and crime against child, advocates should not ask for any time. They should not ask for any passover. They should not try to delay the justice. If our client is innocent, let him get the acquittal. And if my client is actually involved in the crime, let him face the rule of law. But delaying the justice actually sends a wrong message to the society. So if all advocates collectively in Assam takes a decision that will not seek any time from the judges, whether it is high court or whether it is a district judiciary, session judge or any forum of court, that will not take any time when the matter is related to rape, molestation of our sisters, our mothers, and of course the cases related to the POSCO. In Assam, if we can create that healthy environment, I think society will be very, very appreciative of our judicial system, and our advocate must come up to create that environment. I think even in our district bar association, some decisions should be taken collectively that none of our members will take time, seek time when it comes to a case related to crime against women and children. I have no problem if judiciary accuse anybody, because every case which police brought to the for trial may not be correct, police may be also wrong. But whether it is right or wrong, let the decision be taken in a very, very fast-track manner. Recently, I have seen that our district judiciary has disposed lot of POSCO cases in very, very fast and efficient manner. Somewhere prosecution has lost, somewhere prosecution has won. Winning and losing is not important, but a strong message has gone to the society that now everybody is active, everybody is concerned. I am also have a concern that in many Lower Assam districts, the victims are being forced to compromise the case at the trial stage. In many a times, the victims comes to the court and they stop giving their deposition, or they say that we have compromised. I have seen that in Borpeta district court, the case which ends in compromise is much more than what ends in trial. So I think those are the areas where we have to be more careful, whether it is a compromise or whether it is actually a stage managed affair. I think we must go behind we must inquire the entire situation, we must lift the veil, and we must see that compromise has been made under duress, or it is actually something has happened or solution has come out among the family. So this is one of the reasons whenever I go to Borpeta, I ask police, what is your conviction rate? Police says, sir, conviction here, it is very difficult because at some point of time both the parties compromise. Now once a crime is committed, compromise cannot be answered. Once crime is committed, the person must get punishment, and once crime is committed, cycle has to be in conviction or acquittal. It can't be a middle way. I think these are the things which we have to look at it very, very intensively. Ultimately, a just society can only secure democracy for us. If people do not get justice in the court, then people try to seek justice from the police. Now recently I have seen many incidents, once a rape or once something happened, people officially comes to police that shoot the culprit, because there is a system which is developed for instant justice. Now police cannot give the justice. Giving justice is the judiciary prerogative. Now if we can ensure that no, even if I arrest, I complete the investigation within 2 months and I can complete the entire trial process in 1 year, I think people will not seek instant justice. But whenever people get frustrated in the court, then they start asking for instant justice. I think these are the points which our advocates, judicial officers has to be deliberated. Collectively, we must find out answer. And my request that not a single person who is actually involved in crime against women and child should not be spared in any way. And of course, at the same time, no innocent should also be given punishment. I think these are our collective responsibility, and we must achieve this objective together. Once again, I would like to thank Honorable Justice Sri Vijay Bishnoi for coming all the way to Lakhipur to inaugurate this court building. This shows his responsibility towards the district judiciary. Normally, a chief justice coming down to a place like Lakhipur to inaugurate a sub-divisional judicial infrastructure is not very commonly known. These are exceptions. He travelled to Bukathat last month. Today he is coming to Lakhipur. This is very, very encouraging things for the district judiciary, and I am sure that under his leadership, our judiciary will grow further. Once again, I offer my deep gratitude for everybody involved with the construction of this infrastructure. Moi aji ei sundor dimtut amar Lakhipuror raijok ei court buildingor babe बहुत moi অভিনন্দন জনাইছো। লক্ষীপুৰত বহুত ডেভেলপমেণ্ট কাম হৈ আছে। কিছুদিন পিছত মই ইয়াত আকৌ আহিম। আমি ইয়াত এখন জিলা চিকিৎসালয় স্থাপন কৰিম। মোৰ নেক্সট ভিজিটত মই জিলা চিকিৎসালয়ৰো আধাৰশিলা স্থাপন কৰিম। আকৌ এবাৰ মই লক্ষীপুৰৰ ৰাইজক বহুত ধন্যবাদ অভিনন্দন জনাই মই মোৰ বক্তব্য সামৰণি কৰিম।